The legal definition of child pornography here in California is material that depicts children engaged in or simulating sexual conduct. So these could be images of children engaged in sex, masturbating, in erotic poses, sometimes even just children standing around naked. Now keep in mind that not every image of naked children would be child pornography in a legal sense. Parents, for example, often have nude pictures of their children that they keep as part of the family album. And that's considered appropriate and would almost never be prosecuted. But if somebody has hundreds of images of naked children that he has no relationship to and no legitimate reason for possessing, well, then that person's in danger of being prosecuted. Now, keep in mind, it's obviously illegal to make child porn, to develop it, to advertise it, to distribute it. But it's also one of those crimes where it's illegal even to have it for your own personal use. And a lot of people don't quite understand that concept. They think, well, if I have this in the privacy of my own home and it's only for my own personal use and I never would cause harm to any children, then why is it illegal? But the fact is the legislature says it is, even to possess for your own personal use. Now, a conviction for child pornography, whether it's possession, advertising, distribution, making child porn, it's almost always a felony that would cause you to be sent to state prison for years, and you would almost always be made a registered sex offender and be on Megan's list and have to register as a sex offender for the rest of your life. So it's a devastating thing to be convicted of. And if you're charged or investigated, you want to do everything you can to avoid conviction. Now, here at our criminal defense law firm, we've successfully defended many people over the years who have been charged with child pornography. And sometimes we find that the police violated their rights, had an improper search warrant, maybe didn't have a search warrant at all, committed an illegal search and seizure, violated their privacy rights, their Fourth Amendment rights in seizing images and evidence. And in those situations, it may be possible, and often is possible, to get the evidence excluded from court and get the case dismissed that way. Also, just because the police find images, let's say on somebody's computer, that doesn't mean that the images belong to them. There may be lots of people who use that computer. And certainly today, in an age of pop-ups and spyware and adware, people get all sorts of things downloaded on their hard drive and cookies on their hard drive that they didn't even know about. We see that all the time. So somebody who is charged with possessing child pornography or any sort of child porn crime really should contact us here at Shouse Law Group. I'm criminal defense attorney Neil Shouse. In my former career as a prosecutor, I was involved in investigating and prosecuting many child pornography cases. And I know how the state puts these cases together. Now, as a defense lawyer, I represent people accused of this crime. If that's you, contact us here at Shouse Law Group. Let's see what we can do to get the charges reduced or dismissed.